What's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. And in today's video, we're going to talk about debt collectors requesting documents and debt collectors providing documents in a court summons. And we're going to talk about the two, uh, with them providing documents, how you can actually use those documents that they give to you against them to make them dismiss your case. And I'm going to give you the actual reasoning behind that. And then I'm going to also talk to you about a request that for bank records on how they're trying to add to their case, the factual side of their case when they're suing you in court for a debt. They want the reasons why they want to request your bank statements. Um, you might be thinking it's for a different reason. So the first part is in the use of requests for admissions. Um, so when they provide documents, you're going to get your court summons, and you'll see these exhibits. It'll Exhibit A, Exhibit B, and it'll usually have affidavits for the purchase of the debt. They could have an affidavit for one of the employees of the company, of the debt collection company, stating that they reviewed the records and that it looks correct with the normal, like with a normal uh, uh, per business practices of keeping records, that it looks normal, that it doesn't look abnormal. And that documentation is from the debt collector. You won't get that type of documentation from the original creditor. And even if you did get it from the original creditor, these are the holes that I see with those documents. So first, we'll talk about the affidavit that they'll give you for the sale of the portfolio. They're giving that record to the court, that document, that attachment to the court, as to prove that, like, that's their foundation of building everything against you, and they want you to answer to those. They're going to have you. They want you to answer to all of those documents. And so first, with that document that they purchased the portfolio, the proof of sale, when they take it over, they might use words like assigned or whatever. It doesn't matter. Bottom line, they purchased the debt. When you look at that document, it's always in there. I've never seen one that didn't have it. It will say that the debt collector who purchased the debt, or whoever, the portfolio company who purchased the debt, assumes all responsibility for any errors that's in there. Or it may not state any errors, but it'll say for the whole portfolio. So if someone filed bankruptcy and the debt collector tries to go and sue that individual, and that individual says, "Hey, you can't even contact me because I filed bankruptcy," um, the debt collector assumes all the responsibility for that issue. Now, they may not get in trouble for it, because there's been court cases that state that if they did not know, that they can actually, say, "Hey, we were not aware and we did stop and cease all collection once we were made aware of it." But that is the whole, like, that is what makes this whole thing a problem, is that the original creditor does not state that 100% of the portfolio is accurate. Now, I say, the way that I always say it is that 100% of the portfolio, because if any part, it's just like a barrel of apples. If you have one bad apple that has spoiled and poured over all the other apples, something could be wrong with the portfolio. You could have a barrel of apples where only one apple was spoiled and it didn't pour all over the portfolio and all over the other apples, and you can just take that apple out and it's okay. With the strategy to use against debt collectors is to just put it on record that you want something stating that the entire portfolio was accurate. Now, you might be saying, "Well, it's only pertaining to my case." Well, it does only pertain to your case, but see, the way that they presented it, And when I look at my law book, the way that they presented their information is what will actually get them to potentially withdraw their case, because they, trying to make this whole thing look big, presented that document from the original creditor, the sale, because they have to produce how they actually became the owner of the debt. They produce that document, but the original creditor is not going to break down and put every individual's name on there. So the whole document pertains to the whole portfolio. And the original creditor never stated on there that the portfolio was 100% accurate. So, with that specific information, it states here in my law book, if he, they say he, if he has to prove the objection is based on a lack of personal knowledge, which would be, I don't know if the portfolio is 100% accurate. And this is hard to do if he has raised it in the complaint, which they raised it in the complaint by providing that documentation saying that the portfolio, well, saying that they purchased the portfolio and took control of the whole portfolio from the original creditor. So from their own documents that they've provided, you're able to question that document because there's relevant information that should have been given with that document. It's not your fault that they didn't provide that on there. And just to let you know, to this date, and I've seen probably over 1,000 court summons, and none of them with the affidavit of sale has ever had the individuals specified the individual's name and complete account number on there, and none of them, not one has ever stated that it did not have any errors. It always stated that the debt collector takes on the responsibility of anything that goes wrong with that portfolio. So now let's move over to the next document. One of the next documents that they could potentially place in there, which they always do place in there, is the last statement or the last couple of statements that you were provided by the original creditor. Now, this goes to proving the claimed amount. This is their document. They're saying that you owe this big amount, and for the purposes of this example, we'll say a credit card account. There's given one or two final statements, and it has one big amount on there. Utilizing their own documents, which goes right back to what it has here in the law book under the use of requests for admissions from when they produced those documents and provided those in the court summons. They did not show how to prove that claimed amount. They just gave a document saying, hey, it's $5,000 and here is the last statement. And yes, without question, they are allowed to do that, thanks to the representative here in the state of Wisconsin, where the domino effect went to all 50 states, where all they had to do is provide one or two final statements from the original creditor to establish. That's all they had to put in there to establish their claim, unless questioned. When you question the document that they've presented, you question it by saying, I do not recollect this amount and I want you to prove your claim. Please provide all of the charges, all of the payments, all of the credits, the interest rate charge, fees, rewards, whatever. You throw the whole kitchen sink to request the documentation from them. Because they've provided that documentation, they've opened the door saying, we have all the documents. Basically, what they're trying to give an impression to the court is that we have last two statements, but we have everything else. But we just put two just to kind of shorten out the stack so you don't have to go through all the paperwork. But when you ask the question, well, I want to see all of the paperwork, they're not able to produce it. And this, again, could back them up to where they say, we want to dismiss the case because we're not going to be able to produce those documents. They gave the impression that they had the documents by giving one or two of the final statements. But when you ask the question to prove their full claim, because on those two documents, unless you charge $5,000 on one, or if they gave two and you did 2,500 and 2,500, it is not going to add up to the claimed amount that they have. It is just not going to happen. And then we also want to throw in there having complete account numbers. We want them to always have complete account numbers for everything, so you can get a good recollection of the account that you're dealing with. You could have had multiple accounts with them. So those are two very good nuggets that you could utilize to force debt collectors into dismissing your case. I know that this works. We've had several, I mean, several cases that were dismissed solely due to these reasons right here, because this is where you're asking for documentation or complete documentation off of the documents that they've presented. You don't want to have them try to back you up and say, you need to produce documents. I don't have any documents. You are the one that are submitting your claim, and I want you to give me the remaining documents so I can review them and determine which way I want to argue my case. Now, here is one that they have been adding in that I want to make you aware of if you have not uh, heard about this from other videos, or if you've gotten a court summons and you've written your response and they come back with this on the last line. This is something that they're doing with a lot of them that are coming back where the debt collector does not want to dismiss. They want to actually push this on and take their chances on winning. They have on all of the documents that I've seen, they have a final question, and that's where they want to have the defendant produce the bank state, any banking accounts that they have, all banking accounts that they have. Let me tell you the reason why they want them to produce those documents, because if you read the complaint, uh, the court summons or the complaint that that they submitted, it will always have an enrichment line. Most of them, not all, but I would say 99% will say that you enriched yourself. And because they want to show that enrichment, what they will do is they will say, okay, if you I want to see your bank accounts. So they have two motives on this. Number one, they want to see if there's any money or anything that they can take if they end up winning, because they were trying to set up for their summary judgment. But also, they want to show more proof that you were enriched by utilizing the money from the credit that you received. You'll see this a lot with personal loans. You'll see this a lot with payday loans, lawsuits, any type of lawsuit where you're going to actually get the funds and have to put them into your account, or it was put into your account by electronic transmission. They want to see your account so they can say, Judge, look, right here, these are the funds, 100% of the funds went into their account on this day. Now, uh, what I would, this is, and I want to put a disclaimer with this here. I'm not an attorney, and I'm not giving legal advice, and I'm not giving legal advice on this. I'm just going to tell you uh, what I believe could potentially be an out with this. So, what I've when looking at the different situations that individuals have, and they're asking people to produce those documents, what I believe would be there's two options. There's two options. You can force them to make the judge produce those, make you produce those documents, You can wait to your court date and you can, submit your responses. And on that line, you could just say that you do not, uh, you know, for your reasons, don't want to produce those documents. You could say because of your privacy or whatever. Um, the other thing that you could do is you could just state that none of my accounts had anything to do with this. Even though they're trying to show the enrichment, you could just state that none of these accounts did it. Because see, they have two reasons why they're trying to do it. They're trying to establish for their summary judgment if they can have anything to go after, and then number two, they want to show that enrichment. But it's a tricky situation because what they're actually doing is they're actually, in my uh, opinion, is that they're kind of trying to prove their case with everything else, and then they're trying to move forward on like anticipation as if as if you were going to lose automatically. And then also I think with the question, when I've seen it with clients and they see that question, they feel like it's a trap, like this is a trap. If I answer to this, it's a trap. If I don't answer truthfully, it's another trap. And that's why you're gonna have to make your own determination on that. um, I've looked at all of the different avenues on what you could do to potentially answer that. uh, you know I believe, even though this is like a request for documentation, that you do not have to supply any information that would in turn uh, make it look like you're, not to say that this is like a criminal case, but to make it look like you're guilty of what they're trying to accuse you of doing. So this a very tricky question that's in there, and more. I'm still seeking out more information on how that could be answered, even with the attorneys that I work with. Uh, this answer, everything really just falls back onto the other documents. Like they don't have a good answer for this when they've always just had people produce the documents, and then with all of the information that's out there, the judge is going to make a decision, and that might be the way that it has to go. But I've always stated, I mean, you can see how people are managing through cases right now with all the stuff that's going on in our country. That if you kind of figure out a strategy to delay and request more documents, request that they give you more information, that you could potentially uh, push the debt collector into situation where they're just saying that they cannot produce the documents, and even though this was one that you would be able to produce, they can't produce the other documents or substantiate the other documents that they produce to prove their case, and they can push them into doing a dismissal on your case. So I'm still doing my research on that. Because there's still a lot of questions to be answered. And it seems like it depends on what um, jurisdiction you're in, what judge you get in front of. It just all of it is different. Another thing that I want to talk about before we end here is that um, when you go to court, you need to be prepared to defend yourself. Um, if you have documents that you've produced and you're making getting a response for the court summons that you're up against, if you write it or if you have someone take care of that for you, you still have to read it because the judge can ask questions of you and say, well, why did you ask this question? And if you're just taking a prepared document in there and you didn't read it, and they're like, well, you're here to represent yourself. Why did you ask the plaintiff this question? Or why did you request that they provide this? And you're just standing there like, I don't know, even though you're the one that gave them the responses to your summons. You can end up losing your case just solely based off of where they just, you're not even really a contributing party to the case, even though you're there representing yourself. You have to know what you're asking. So you need to read it thoroughly. So if you're ever asked any questions, which could potentially happen, some of the times that you could get dismissed just right off the bat by the debt collector. Some of the times the judge may ask you like a few questions, like why did you request that they give you all of the documents to prove this amount? And you would just state, well, just like I put in this my response, because there's charges that potentially could have been disputed, and I want to make sure that they're not included. I want to get a full record. And judge would say, well, that's a good reason. Turn to the plaintiff. Do you have the full record of the account so the defendant could review them and come to a determination if that amount is that you're claiming is true? And they say, well, we don't have access to those documentation. Judge said, well, case dismissed because you can't prove your claim, or they give them more time or whatever. You just never know. But you can't go up there and just be like, you have your statement prepared and you don't even didn't read it, didn't pay attention to it. All right, so if you need help with your credit, please visit us at thecreditrepairshop.com. Watch video, what makes us different, so you can see my 8-point validation process, two-phase settlement process. If you need your credit reports scores, go to the website your3scores.com to get your TransUnion, Equifax, Experian credit reports. If you have debt collectors coming after you, grab my 3-pack of letters, statute of limitations, debt validation, cease and desist collection activities letter. The links are below this video. And if you need help with third-party debt collectors or original creditors who are coming after you, there's a link below where you can get help, or we can review your court summons and see what options you might have. It could be to move towards a settlement. It could be where you have a potential to win your case. You never know. So we'll do that review for you. You can send that to go to my website, thecreditrepairshop.com, and upload that into our live chat, and we'll do a review for you. Thank you for your time. Please subscribe to the channel. Please post your questions and comments. This is Stephen A. Williams, President and founder of thecreditrepairshop.com.